Hey guys, good afternoon. Welcome to my channel. My name is Debbie. We are, excuse me, we are here for the charging conference for the attempted honor killing trial. We are almost done. We are going to listen to the charging conference, and then we will be doing closing arguments on Monday. There will be no court tomorrow, so we will be doing some Phil Spector trial tomorrow, which we are also almost done with. And I missed Jennifer. Well, hi Jennifer, if you end up on replay crew. Hi, sorry I missed you this morning. Hey, Judy and my lurkers and my replay crew. Love y'all so much. Love you guys. Love, love, love. Okay, this is another one of those boring things that we do because it is part of the whole trial experience and it is a must do because we are gavel to gavel here. I always say you must take the
Where this court's policy
good with the bad,
the instructions so that it'd be clear that
boring,
together.
because that is how this works. To do it all. And if you don't want to watch
Is
it,
before the
that's
court
fine,
today.
I'm gonna stream it. Doesn't mean you have to watch it. I'm gonna stream it.
We are on cases 24-1-13034 and 24-1-132-534, State versus Ali. This matter is before the court today. The evidence has concluded in this case, and the court needs to address appropriate jury instructions. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present with Mr. Ali, representing Mr. Ali, and Mr. Leary is present with Mrs. Ali and representing Mrs. Ali. Yesterday afternoon, after the conclusion of the evidence, I provided to the parties draft instructions and explained kind of how I put those together. I would just indicate, in case there's any questions, the copies I gave to the parties were double-sided. The original instructions will not be double-sided. I do run instructions continuously, i.e. not a single instruction on each page, but I will never break up an instruction between two pages when the final instructions are put together. As to, and as I refer to numbers, I am referring, of course, just to draft instructions, but I'm not going to repeat the word draft over and over again. So as to instructions 1 through 3, any issues with those? And I don't know if Ms. Stone or Ms. Zoe are going to be dealing with issues related to jury instructions.
I will. I'm sorry. May I remain seated while we have this conversation?
Of course.
Thank you. No issues. What's 1 through 3?
All right, Mr. Kading.
No issues, Your Honor.
Mr. Leary.
No exception.
All right. Number 4. The state and Mr. Kading submitted the same instruction. Mr. Leary submitted an instruction that has bracketed information from the WIPIC, which includes what is often referred to as the abiding belief language, the last sentence. And I have that bolded in the instruction so that it would be clear that that was the issue that I would be addressing. Mr. Leary, I thought I would hear from you first.
As I'm sure everybody is well aware in terms of the arguments associated with WIPIC 4.01, it is not error to include that language. It is discretionary as defined by the comments and by the bracketed material in 4.01. I do object to language where the court is directing the jury as to whether they are satisfied beyond a reasonable doubt. I would also note that in the introductory instructions that the court provided to the jury when
Turn the lights on.
discussing reasonable doubt, the court did not include the abiding belief language, which I did note.
I'm gonna be bored. I wanna
Would ask
hear
to
what
be
I'm being
consistent
bored by.
and simply, I object, and I'm not aware of this court's policy, and I know that courts generally have a standard policy, so that's my argument.
Thank you. Mr. Kading, your instruction did not include that language.
Mine did. The abiding belief, I believe it did. It did not.
I don't think so, but I could have missed it, certainly. I'm looking at your initial instruction, and you included the abiding, so you want the abiding belief.
I don't
Language.
object to it. I mean.
Okay, because that's what was in your proposed instruction. Yes, so that's, and I apologize if I wasn't clear. You did propose that language?
Right.
Yes, all right. And that's why I indicated on the draft instructions that it was only Mrs. Ali's instruction that had that language. Ms. Stone?
Thank you, Your Honor. Your Honor, I think counsel is correct as to the law regarding the abiding belief language. That is discretionary for the court. Obviously, the state would note that that language is regularly given. It is appropriate to give that language. The state's position consistently has been, when we are talking about reasonable doubt, that is not a objective measurement that the jury can look at information and say it's this percentage. There's no numerical value. And while we talk about it regularly as attorneys, especially as criminal attorneys, in the course of the law, that has become, I would argue, a very, we have much more familiarity to it. The first time that most jurors hear that as a measurement for deciding a case is during the course of the actual case when they're on jury duty. So they don't have that same familiarity. The state's position is and will remain that by giving essentially the opposite side of that coin, that helps the jury decide what otherwise could be I don't want to say amorphous, but a oftentimes difficult standard to apply with any level of certainty. So by giving them the opposite of of reasonable doubt with abiding belief, that is the opposite side of that coin, that helps give them another means for discussing with each other if they have a reasonable doubt. I would ask the court to provide that as additional definition for them to help them make that consideration. It is appropriate, it is not error, and I think it is helpful to the jury.
Thank you. Anything further, Mr. Leary? All right. First of all, Mr. Leary raised the issue as to when I gave my opening information to the prospective jurors, to the entire panel, I give them, what I tell them is a definition of reasonable doubt. And Mr. Leary is correct. I did not read the abiding belief language, and I don't ever include the abiding belief language when I give that just general definition to a jury. These are the jury instructions, which are different than the court giving a jury a general idea of how reasonable doubt is defined. And I would posit that no one will remember, first of all, exactly what I said at the time of those instructions. But the reason I don't give the abiding belief language is that I don't want someone who is a defendant to feel that they cannot suggest that if I give it, that means it will be in the final instructions. I want both sides to have an opportunity to argue that to the court, and so I don't want to read that on the off chance that someone would remember that they heard it differently. That's why I don't include it. It allows both sides the opportunity to argue to the court at the time of instructions whether or not I should include the abiding belief language. And I don't like to have a policy as it relates to jury instructions. as it relates to how I give jury instructions, I don't think that's appropriate. I think the court has to decide every time what are going to be the appropriate instructions in this matter. I find, and as the lawyers have properly indicated, if the court includes the abiding belief language, according to our pattern instructions, that's appropriate language and consistent with the law. If the court did not give the abiding belief language, that is also an appropriate instruction and consistent with the law. I am persuaded that it is appropriate, and I will include the abiding belief language in instruction 4. Any issues with 5 through 7, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Larry?
No, Your Honor.
Ms. Stone, any issue with number 8?
My question, if it was necessary, Your Honor, in terms of the state going back through the evidence, I saw statements obviously that Mrs. Ali had made, which had come in, and statements that Mr. Ali had made, or I guess not made, but referenced in terms of arguments between his daughter and students at the scene, but not as it relates to each other, or that necessarily discussed the actions of each other, as the state's position is that Mr. or Mrs. Ali did not reference really her husband's actions at all. Her husband was referenced only in terms of what people were doing to her husband. So I don't think that it's necessary, and I think that it could be confusing to the jury in terms of how they identify what is happening in the case. That instruction number 8 is essentially a rule to address Bruton, and we don't have those types of statements here. There's no confession statement that implicates their co-defendant in terms of behavior. So I think this instruction number 8 is confusing, and I don't think it fits in this case, even though it is a co-defendant case.
All right, thank you. Mr. Kading?
And Your Honor, I don't know what the final argument of the government is gonna be, but I think that this instruction is necessary, because I know there has been references to statements you made, after this event that the state has been eliciting from the witnesses. Obviously, Mr. Ali is part of those.
Bless you.
So I think it's appropriate to limit, the statements that she made to be, used in arguments in case, against her, but not against Mr. Ali. So I would ask the court to include it.
Mr. Larry?
Well, I can think of one example. I think it was Officer Bell, maybe Sergeant Bell, said that Mr. Ali told Mrs. Ali to just go home. Given that my client is charged with burglary and there's an argument that she had been trespassed, that statement shouldn't be used as evidence of the burglary or trespass, as to why. I didn't get a chance to cross him on why he wanted her to go home, because she wasn't supposed to be there, or just because the event was over and just go home. So I do think that instruction 8 is appropriate.
And so I'm not making that argument, so insofar as that's helpful, I don't think that applies that burglary plainly was committed prior to that statement being made. So I understand that concern. That's not an argument the state's making, or would make, and I don't think that makes that instruction applicable, I guess. My concern is that Mrs. Ali describes what she sees as it relates to what is happening to her husband. My concern is that whether the jury looks at that and says, well, then do we need to take what Mrs. Ali said she says and cut Mr. Ali out of those observations altogether, even though it doesn't address any behaviors done by Mr. Ali. In fact, it's completely silent as to behaviors by Mrs. Ali, or excuse me, Mr. Ali. So that's my concern, is that it is going to be confusing to the jury in terms of how they apply it to Mrs. Ali's statements about her husband.
What specific statements are you concerned about would be confusing to the jury if this instruction were given?
Yes, Your Honor. My concern is that the way it implies is Mrs. Ali very specifically says she rolled up. She doesn't say roll up, but she and Haneen arrive on the scene. and that she is watching a student beat her husband. They're punching him over and over and over again. Those were the statements that she continues to make. My concern is that the jury, in reading this instruction based on essentially the nature of it, that somehow then they have to pretend she doesn't say Mr. Ali and it's just a person or someone else. That they shouldn't use it that way, but because of the way that it reads, my concern is that somehow they will neutralize and take Mr. Ali out of that statement by Mrs. Ali, even though it's not attributing any actions to Mr. Ali, and there's no statements regarding a confession or conspiracy whatsoever. So that's the state's concern. I don't think it applies in this case for those reasons, and I think it can be confusing to the jury.
Mr. Larry?
The state said that they weren't going to argue, but that's not the only standard. You are telling the jury how they are to weigh the evidence and how they may use the evidence. And just because the state doesn't make an argument with respect to the burglary, it doesn't mean that the jury might not use Mr. Ali's statement.
All right. I am going to give instruction number 8. I think it is appropriate under the evidence that has been presented in this case as it relates to statements by the defendants. I do not believe that it's going to limit the state in how they can argue their case and the facts that have been presented in this matter as it relates to each of the defendants. Instruction number 9, the last clause of that instruction or of a third person was included in the instruction offered by the state and Mr. Kading. That clause was not in the instruction offered by Mr. Leary, and it appeared to me that it doesn't apply.
The state agrees with Mr. Leary's instruction, Your Honor.
All right, Mr. Kading?
I do too, Your Honor. I only included it because it wasn't bracketed, so I agree it's not.
Hey, Terry.
So what I have bolded in the draft instructions will be deleted. All right, Ms. Stone, any issues with 10 through 12?
Only on 10, Your Honor, I would indicate, I think we need a, he or she does any act that is a substantial step.
All right. If I add or she, any issue with that instruction, Mr. Kading?
No, Your Honor.
Mr. Leary? All right, and I didn't ask you, any issues with 11 or 12, Mr. Kading?
No, Your Honor.
Mr. Leary? All right. Any issue with number 13, Ms. Stone?
No, Your Honor.
Mr. Kading?
No.
Mr. Leary?
Yes.
All right.
So I guess at the outset, as evidenced by the pretrial brief and representations, the state had previously indicated, despite what was in the amended information, that they were not proceeding on an accomplice liability on the murder. I reached out to the state after I saw their draft instructions to say, had that position changed, or was this included in error? And they indicated that they did intend to offer this with respect to the attempted murder, and the specific explanation was based on Ms. Wagner's statement as to the actions of my client in terms of that she saw mom striking the man. And so her testimony was different from that, but regardless, I don't believe that there is, so I just want to be clear that the accomplice liability applies to the attempted murder, is that
I wish
correct?
they would use the
Yes.
microphone.
And only the attempted murder. So operating from that, so
No, I mean, she's charged as a principal or accomplice several times. If we're talking about the attempted murder, which I understood the question was, then yes, it applies to the attempted murder, and she has been charged that way consistently. I think that there are two theories that the jury could apply it on, either as a principal or as an accomplice, but both of those are available to the state. And while we did discuss very much earlier on in the case a different scenario, that much later in the case, as we talked about it, Mrs. Wagner's information is different, and I think the testimony at trial is consistent with the charging, and the state intends to argue that as well. I think there's two theories that the jury could find that on, based on the testimony that has come out at trial.
I think we're on the same page.
Okay.
I wanted to be sure that I was only talking the accomplice theory, in addition to the intentional theory on the murder two, is the only, the count of attempted murder is the only account where the state is proffering an accomplice, not the assault two or the unlawful assistant. Is that correct, or am I incorrect?
I think counsel is incorrect. I think that
Okay.
both of those apply. I think the stronger argument, certainly for both of them, for the state is the principal, but I think the accomplice liability applies for both. The state would be arguing both of those as charged.
Okay, that's helpful. Thank you. So the question then becomes, in the instruction, is there sufficient evidence for the jury to consider my client?
This is really hard to hear, guys. I know, and I'm sorry. I gotta stop it for just a minute. There is this folklore, superstition, I don't know what you call it, that people die in threes. People in similar groups die in threes. It is true. I don't care how coincidental it may seem or superstitious or whatever. As a nurse working in a nursing home, I can tell you it is very true, because we would have people in the nursing home die in threes. My entire life, I've noticed a trend of people dying in threes. And I've noticed it in celebrities. And I have to tell you guys, this week, I'm heartbroken right now. 3 people that were icons in my childhood have passed this week. And I don't think I've been upset at celebrity deaths before, but for these 3 to go in the same week has severely affected me. Malcolm Jamal Warner, who played Theo Huxtable on The Cosby Show, died earlier this week. He drowned. He was 2 years younger than me. He got caught in a rip current on a family vacation and drowned. And of course, Ozzy Osbourne. He was 76. He had Parkinson's disease. And I just found out that Hulk Hogan, the WWE wrestler, died. He was 71. And that's all I know. It's been reported in 2 places. I've seen it in more than one place. They're not releasing yet cause of death. So I'm very emotional right now. I'm very upset. I just needed to get that off my chest and tell you guys. I don't know if you care. It's my childhood. My childhood. Part of my childhood is gone. So just say a prayer for their family and their loved ones and their fans. Because it's very sad. It's a sad week. Sad week for Generation X.
As an accomplice, and I will start with the attempted murder too. If we look at the video, we know that in Exhibit 34, you can see at 213, you can see the Honda Element going the opposite direction on Mullen Road from the bus. And it then turns, the bus then parks, and then the Honda Element turns into the parking lot. The Element is already turning into the parking lot while the initial physical confrontation between Mr. Ali and Isaiah Williams. And can see the initial confrontation. So she then pulls into the parking, actually Haneen pulls into the parking lot, and on Exhibit 114, which is the Timberline High School video, we can then see her running across the parking lot, and there's been no testimony as to what is visible from there. We can surmise the distance. We know there are cars that she's running around, and that there are kids surrounding Mr. Ali, Fatima Ali on the ground. We then look at Exhibit 89, which was discussed yesterday, admitted earlier in trial, which shows the arrival of my client standing next to the truck with the large Douglas fir tree in the middle of that still shot exhibit. So we know there's been no discussion about a conversation between my client and her husband about solicitation, a direction, commanding, encouraging, or requesting Mrs. Ali to commit the crime of attempted murder. There's no testimony that she agreed to aid in the planning of the commission of the crime. So the sole question is whether or not she aided Mr. Ali in the allegation that he committed attempted murder. We know that mere presence and knowledge of criminal activity, so more than mere presence and knowledge of criminal activity must be shown to establish that a person who is present is an accomplice. That's in the instruction. So, and then there's case law that talks about it's not should have known, it's that they actually knew. Now, the state has made a large effort, or has addressed this topic repeatedly, that at no time did my client tell the police, talk about strangulation, or talk about or seeing her husband strangle Fatima. She talks about the repeated punches to his head over and over and over again. Furthermore, the court is well aware of the positioning of everybody. So we have Mullen Road, we have Fatima on the ground, we then have her dad either on top or laying in between Mullen Road, so Fatima, Mr. Ali, and the school, the direction in which she's coming. There's been no testimony that, in terms of what was visible from the parking lot, there's no pictures or evidence that detectives went afterward to basically show what is visible from the parking lot. There's nobody says it was very clear from where I was standing next to the truck or between Mr. Ali and the truck that it was very clear that what was happening. What she says is I could see him being struck in the head by Isaiah. So the state has to prove that she has actual knowledge that he was attempting to kill her, and that she then, with that knowledge, agreed to assist in the commission of that crime. And there simply isn't sufficient evidence for the jury to be instructed on attempted murder 2 as to attempted murder. So then the next question is, as to assault 2, with respect to strangulation, same argument. She comes up, and we know from Mr. Wagner's arrival, he comes from one side where he can actually see Fatima, intervenes And his testimony is Dad immediately, he removed Dad's arm with some force, but there really wasn't much of a struggle. And he basically was able to immediately stop Mr. Ali and the actions of Mr. Ali. So then we go to the unlawful imprisonment. Now, the court noted yesterday in the halftime motion that strangulation isn't a part of reasonable parenting. But we have to look at it, again, from the eyes of my client. She sees, presumably, we don't actually even have testimony that she did see, or could see, or made eye contact, but there's an argument, circumstantially, that she was able to see her husband and able to see her daughter as they passed by the bus stop on Mullen Road. And in the video, 34, there is nothing that's happening at that point. There's been no physical struggle, there's no punches, there's no strangulation. So she pulls into the parking lot, she knows presumably where they are because that's where she ran. There's no testimony that anything that happened beyond those kids is visible. She then runs through cars, sees arms punching her husband's head, goes into the crowd, same time Wagner stops Mr. Ali, she then grabs her daughter. So, in the split second that this all happens, mere presence and knowledge of criminal, more than mere presence and knowledge of criminal activity must be shown. If we're talking also about, self-defense, we talk about mistaken belief, right? Which is a somewhat analogous here. There's nothing to suggest that he says, I'm going to kill my daughter. And that was the purpose of going to the school. So there's nothing to suggest, again, that solicitation, command, encourage, request. The only issue is whether she aided him in attempting to kill her daughter in the fraction of a second where she arrived with Mr. Wagner and he diffused. There isn't a basis for accomplice liability. Now, the state is also arguing, and I'm not arguing for a halftime motion, as that the actions of my client as she's holding her daughter, the state is alleging assault too for that, and unlawful imprisonment. And I'm prepared to argue to the jury against that, but to say that she is an accomplice to what happened before she arrived, and in the fraction of a second that she's there, I think is an abuse of the accomplice liability statute and legal theory.
Just one moment. All right, Ms. Stone?
Thank you, Your Honor. Your Honor, counsel, in his argument, says that she sees her husband being punched repeatedly. We saw that from the arguments, the body cam video of Mrs. Ali's statements that she sees her husband being punched repeatedly, over and over and over again. She in fact demonstrates that to Officer Chavez over and over and over again. Those punches can only be happening while her husband is strangling her daughter. Josh Wagner, who quite plainly gets there after Mrs. Ali, that is on video. That was also what Mr. Leary just indicated in his argument, because that's consistent with the video. Mrs. Ali arrives not long before Josh Wagner, but just before Josh Wagner. Josh Wagner, who knows none of these individuals from Adam, immediately says, as he's walking up, he can see that this man is strangling a young girl. Initially, as he is stopping his vehicle, he believes it is a group of kids fighting another kid. He says as soon as he's out, he can see that it is a man strangling a child. Mrs. Ali arrives at that scene just prior to Josh Wagner, not long prior, but just prior. And instead, she, who knows both of the parties, she obviously knows where she's going to get to that bus stop in the first place. So she has communicated with her husband in some way. That is the state's argument, because otherwise she has no way to know to go to the bus stop from where she is sitting, even by Mr. Leary's own argument, out in the parking lot, if that communication has not happened. So of all the people there, even if she knew none of that, she knows who those individuals are. And so everybody there who doesn't know anyone else from Adam clearly sees and testifies immediately that they can see a grown man strangling a child. Mrs. Ali arrives on scene, and instead of assisting her child, immediately starts pulling and striking the children that are there to get them away from her husband. And all of her concern is about her husband. So she's already on the ground at the time that happens. She absolutely is an accomplice to that attempted murder. She is not helping her child. Counsel can make the argument that he doesn't believe the accomplice liability theory applies, or that the state has not met that burden, but all inferences should go in favor of the state, all of those reasonable inferences, and it should be provided to the jury to make that assessment themselves. Certainly she is more than simply on scene and present. That application actually in this case would apply, I would argue, to the kids who are videotaping, to the people who are watching and don't know what to do, not Mrs. Ali, who immediately jumps in, inserts herself, and is not there to assist her child. It does not appear based on the testimony that we have received. So the accomplice liability absolutely is appropriate for the unlawful imprisonment as well, because then immediately upon being released, despite all the information to the contrary from the spectators, she immediately goes into choking her child as well as restraining her child while her child is trying to get away from her, in exactly what everybody else says they saw and that she was there at the same time to see. Everybody identifies that after Josh Wagner does whatever Josh Wagner does to restrain Mr. Ali and have Fatima released from Mr. Ali, all of the striking stops. That is consistent with the video. So if Mrs. Ali is there to see repeated strikes over and over and over again, then she is also there when that strangling is happening of her child, and she knows those parties better than anyone else. So the accomplice liability absolutely should be given in that case.
Mr. Lurie, anything further?
I'll leave it up to the court. I think I would encourage the court to go back and watch the short clip in 34, where you see the arrival of Mr. Wagner and you see the arrival of my client. If you have questions as to the representation of the parties, as to what my client did and what appeared to be visible to her.
All right. Certainly the court viewed that clip, which I believe was played multiple times during the course of the trial, and so I'm familiar with what I saw during the course of the many playing of that video, and I would posit that I saw more and more as I watched it time and again, based upon the questions that were being asked of any particular witness who was viewing that footage. Certainly, as it relates,
I would be after
the information,
my kid
which
got
is not
punched.
ultimately controlling as it relates to the jury instructions. It's whether or not there has been evidence presented, if with inferences, with reasonable inferences to the state, whether or not an instruction would be given, even regardless of how how the matter is charged within the information. I do find that there is sufficient evidence when I view the evidence with reasonable inferences to the state for their arguments of accomplice liability as it relates to Mrs. Ali. As has just been argued on the attempted murder charge, the assault in the second-degree charge, and then I don't know if you want any further argument as it relates to the unlawful imprisonment, but I also would, it's all of those things are linked together in the time frame, and so really, I find that there's sufficient evidence with all reasonable inferences for the accomplice liability for all three, for the attempted murder, for the assault and for the unlawful imprisonment. And so I will be giving instruction number 13. On number 14, the WIPIC indicates that when there is an attempt, that there needs to be an elements instruction separately delineating the elements of the crime. The state proposed number 14. When I viewed that, it appeared to me that the last two paragraphs in the proposed instruction are not appropriate because only the elements, by my reading of WIPIC 100.02, should be included in that instruction. So, Ms. Stone?
No objection to that, Your Honor. State agrees with that deletion. I would also ask, essentially, anywhere it says FIA at this point, we just, based on the way the testimony came out, that we just change it to the name Fatima Ali, and date of birth obviously isn't being needed, excuse me. And
so
that will be throughout the instructions.
All right. Mr. Kading, as to instruction 14 with the suggestion that the last two paragraphs be deleted, up in the first paragraph, it still says the elements would need to be proven beyond a reasonable doubt, so that is still part of the instruction.
Correct, and I agree with the court's analysis on that.
All right, Mr. Leary?
I agree with the deletion of the last two paragraphs. I have no objection to using Fatima Ali. I would object to the inclusion of her birthday because I think it's a comment on the evidence to establish her age.
No, I said not to include it.
So if the court didn't go with your suggestion, I would note an objection. And then with respect to element 1 and 2, it says a defendant. I would ask that it say the defendant. My concern is that if they were to convict one defendant, it would necessarily result in the conviction of the other.
Ms. Stone?
I don't think I have an objection to that.
All right. And Mr. Kading, any objection to me using the name Fatima Ali and removing the date of birth?
No, Your Honor.
All right. Any objection as it relates to the defendant versus a defendant in elements 1 and 2 of instruction 14?
No.
All right. Any exception on 15, Ms. Stone?
Yeah, I think it needs the principal or accomplice language in element 1, that the defendant, that on or about October 18th, 2024, the defendant, and then I think it should be inserted, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step. So I think that language needs to be inserted in there.
All right. And this was your proposed instruction?
It was, yes, Your Honor, it just got left off.
And so, just so that I have the way accomplice.
Or both of those.
Okay. Mr. Kading?
Now I'm confused. So are they alleging that the defendant, Mr. Ali, was an accomplice to his wife's actions?
It's
Because
charged,
this is
I
his
think.
instruction, right?
It is his instruction. I think that it is charged that way. I think that the state is alleging it the state is alleging it as a principal, but I also don't want the jury to get confused when they are listening to Mrs. Ali's, that somehow they have to decide that one person is something more than the other person. And I think that that language is appropriate in that, because it is irrelevant in terms of if they believe, if for some reason they believe that he is an accomplice over a principal based on the information, I don't want them to get tied up in that language. So that is an appropriate statement, and the state is arguing primarily that he is a principal, but that there is a concert of action between the two of them at the time these events are going on.
Mr. Keating?
And Your Honor, I don't know, based on what we've seen, how his actions, which
Louder,
were his own,
please.
he then is laid flat on the ground, not moving. If there's an allegation then that she did something, I don't know how he's an accomplice to what she's doing. Similar to what Mr. Leary was arguing, except my client being there and prostrate on the ground certainly has nothing to do with what's going on with Miss Ali behind him.
All right, anything further, Ms. Stone?
No, Your Honor.
All right, I am not going to, in Mr. Ali's instruction, include the language as a principal or as an accomplice, even giving all reasonable inferences to the state on the evidence that was presented during the course of the trial. I don't find that the evidence is that Mr. Ali, or it could be argued that he was an accomplice on the attempted murder to Mrs. Ali. And so I'm going to leave it as was set forth in instruction number 15. Mr. Leary, any exception on number 15? All right, then we are at number 16. Just a moment. Ms. Stone, on number 16.
Yes, Your Honor, element 1, same request of the state included the defendant, comma, as a principal or as an accomplice, comma, and then did an act that was a substantial step.
All right. Mr. Keating?
No objection to that.
Mr. Leary?
Based on the court's prior ruling, I think that assertion is appropriate.
With your standing objection?
Exactly.
Okay.
And then there is a typo, it should be element 3, not 4.
Thank you.
Your Honor, we ask the defense lawyers to approach the microphone, please.
Yes. Thank you.
Sorry, sir.
All right, number 17. Any issue with that, Ms. Stone?
No, Your Honor, thank you.
Mr. Keating?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Number 18 is the definition of assault. And provided, it appears to me that at a minimum, the first paragraph in instruction number 18, which includes a sentence that is bolded, that paragraph would be included as the definition. I'm not addressing the next two paragraphs yet. Paragraph, any objection to this second sentence?
No, Your Honor, should have, thank you.
And Mr. Keating, you proposed that language that the second sentence be included, and so you agree with that? First paragraph only, instruction 18.
I don't know that the second sentence, actually, I think it's bracketed, right? I don't know that that's something that's going to be argued in this case. That it's an offensive touching. Usually we use that in a lot of other kinds of cases.
I'm talking about the language of touching or striking is offensive if the touching or striking would offend an ordinary person. I'm pretty sure you proposed that language. If you're not proposing it. That's not true.
Okay.
You did not
didn't think it-
propose that language.
Okay.
You proposed just through the end of the first sentence and then nothing further. I apologize for that. That was language that was proposed by the state. They gave the entire 35.50 WIPIC instruction. And so you want just the first sentence?
Well,
Or that's what you believe is appropriate under the evidence, is what I mean?
I think that, that's what we're talking about, is a harmful touching, not an offensive touching in paragraph 1. Their allegation is that, there was actual bodily injury, so paragraph 2 talks, did I move on to paragraph 2? I'm sorry.
No, we're just talking about paragraph 1.
I don't think there was any offensive touching in this case.
Aren't you arguing that, or aren't you going to request that I give an instruction that this was discipline, or that that could be a defense? And so isn't whether or not the touching is offensive associated with, isn't that an argument related to your request that it was a
Yes.
defense?
Now that you mention that, that on the assault 4 would be a appropriate definition.
Well, all right. Mr. Leary, any objection to including the entirety of just paragraph 1, including the language that I have, that one sentence that's bolded for instruction 18, just paragraph 1?
Okay.
All right. So as to instruction number 18, the entire paragraph will be included, and of course it will be unbolded. Now, as to the second paragraph is to be given in cases involving an attempt to inflict bodily injury, but not resulting in battery. That does not appear, from my perspective, to be what the evidence suggests, and that was, that language is not proposed by defense, it is proposed by the state. So Ms. Stone, I would like to know why you would want that included.
Yes, Your Honor. Your Honor, when we talk about the assault 4, I want to make sure, because we've spent so much time during the course of this case with Fatima, that all of these injuries have occurred. So when we're talking about the assault, those additional paragraph instructions make it very clear that when the jury then moves to look at the injuries to Isaiah, try and decide what level of injuries, if they're sufficient, if there's in fact injuries, those two follow-on instructions make it very clear that for the purpose of assault 4, no bodily injury is required. The state does not have to prove that bodily injury exists. And that helps clarify that for the jury, because like I said, we spent a ton of time talking about the nature of the injuries to Fatima. And there is obviously a significant distinction between those two. I would also indicate that Mr. Keating introduced photos that certainly, and I think from states, or maybe arguably look different from the states, and I don't want the jury to get caught whether, well, we don't know that there's an injury, so therefore this assault 4 didn't occur. Those two additional paragraphs make it very clear that the state does not have to prove that, and that is not the definition of assault. There is no injury that is required in that case, and so I am asking that those be provided. It helps the state more fully argue in making that decision.
Mr. King?
Well, again, I mean, we have video of a punch. It seems to me that that's covered by number 1, paragraph 1.
Mr. Larry?
I would have the last 2 paragraphs. My concern is the confusion as to, we're talking, the state wants this for purposes of the assault 4, which doesn't come up until instruction 39, and looking at the 2 convicted of 39, is they have to find that on or about October 18, 2024, the defendant assaulted Isaiah Williams. All they have to prove is an assault of Isaiah Williams in the paragraph defines assault as an intentional touching or striking of another person that is harmful or offensive. And so I think they certainly have the room to argue their theory as to why that has been committed. And my concern is that the inclusion of paragraph 2 and 3 will be detrimental and confusing to my client, who is not charged with a misdemeanor assault.
Ms. Dunn?
I'm confused, I suppose, I'm confused as how that would be detrimental, arguing the law as it applies to the facts in the case, detrimental to a defendant. Count or paragraphs 2 and 3 are the law of the assault. Of injuries to occur, whereas assault 4 is relatively silent about that. So that argument doesn't make sense to the state in terms of how it becomes more detrimental at all, let alone be more helpful to the jury.
All right. As to the third paragraph, I am not going to include the third paragraph. That is the language, an assault is also an act done with the intent to create in another apprehension and fear of bodily injury, and which in fact creates in another a reasonable apprehension and imminent fear of bodily injury, even though the actor did not actually intend to inflict bodily injury. No inference from any of the evidence in this case relates to that portion of the definition of assault. And the WIPIC 35.50 indicates that the third bracketed definition should be used if there is evidence that the actor's intent was not to inflict bodily injury, but only to create the apprehension or fear of bodily injury. And the evidence that has been presented in the light most favorable to the state is the first paragraph definition of assault, that it's an intentional touching or striking, and that is the evidence that has been presented, not that there was apprehension or fear with no actual physical contact. So I'm not including 3.
I wonder if the kids will still date after this.
And I am not going to include paragraph 2 either. The WIPIC indicates that that paragraph, which indicates an assault is also an act done with intent to inflict bodily injury upon another, tending but failing to accomplish it, and accompanied with apparent present ability to inflict the bodily injury if not prevented. It is not necessary that bodily injury be inflicted. As it relates to the assault 4, there is no burden on the state to address bodily injury. It's whether or not there is, I want to get to the language. They have to prove that Mr. Ali assaulted Isaiah, defined as an intentional touching or striking of another person that is harmful or offensive. And the second paragraph is not consistent with the evidence that's been presented, and I don't believe it limits the state in any way from arguing their case or confusing the jury, because the other assault charges, which require more than just the touching or striking, are clearly set forth in the elements, and the court knows that the state can properly differentiate between the assault charges. So
Would the court consider adding the last sentence necessary at the
So she's talking about using the last sentence in the second paragraph and putting that as a last sentence in paragraph 1.
Yeah, I don't object to that.
Mr. Larry?
I do object. My concern is just, my client's not charged with misdemeanor assault, and my concern is it runs contrary to what the state has to prove for assault 2. I understand that there are individual instructions laying out the elements of assault 2, but we're then providing them with a definition that is in conflict with that with respect to the specific. I mean, I think it gets, I would just want this to be clear that we are talking about an allegation of the assault 4, and that's what that sentence applies to.
All right. To ensure, I am not going to include that sentence. I understand why the state is seeking that. Again, as it relates to the charge of assault in the 4th degree, the state's burden is to prove that there was an assault, which is the intentional touching or striking that is harmful or offensive. I do not believe that the jury is going to be confused as they go through this process and apply that definition to the different levels of assault that are alleged in this case. And I believe it actually would be a misstatement if I added that sentence to the first paragraph. I think it could be construed as a misstatement of the law by putting it together like that. All right, instruction at 19. Any issues with that instruction, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Number 20.
Just changing Miss Ali's name in element.
Oh, thank you. Yes. With that change, removing the date of birth and putting in the name, any issue with number 20, Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Any issue with number 21, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
All right. Instruction, as I indicated yesterday, I have instruction number 22, which was proposed by Mr. Kading. He then proposed another instruction yesterday that I did actually add into my draft instructions, but it was after I had sent it to my judicial assistant to print these, and so I had not wanted to reprint everything and renumber everything, but the other instruction that was presented, the difference is that for the lesser included, it was assault in the 2nd degree or assault in the 3rd degree. And as I go through the instructions, if I give those as lesser included offenses, I would include that language in what is currently instruction number 22. So I hear argument as it relates to the request for the lesser included offenses. Ms. Stone?
Sorry, Your Honor, just to clarify, are you asking for the substantive argument on the lesser included?
Yes.
First? Okay. I think that the substantive argument on the lesser included for assault in the 2nd degree is appropriate. I believe that would be Mr. Ali's 23A.
Yes.
I think that is appropriate. I don't think that assault in the third degree, however, where it's been alleged by strangulation, is necessarily appropriate. The assault in the third degree is not a lesser included of assault in the second degree by strangulation. As the state was going through, and certainly I think minds can differ. I through it last night and was looking at it in the manner that it is alleged here. I don't think it can be the argument that only assault in the third degree occurred if the jury believes the state's evidence in the way it's been presented. I think they could believe that assault in the third degree also occurred, but not that it only occurred in this case, based on the argument that it is done as it relates to Mr. Ali by strangulation. So I don't think that assault in the third degree is appropriate in this case.
Mr. Keating?
And Your Honor, I think that third degree is appropriate in a case like this where clearly when you have kind of a mob of people and a attack from behind that was seen in this case from Isaiah and him having a struggle with his daughter. I think it's entirely possible that there may have been a lack of recklessness or intent, obviously, which could still leave us with, well, maybe he shouldn't have put himself in that position and it was a negligent act that caused the assault, which would have been what happened after he was hit. And at that point, I think that an assault 3 instruction is appropriate if it goes towards culpability and mens rea, which in this case it clearly does. If he could have known what he was doing was wrong, but didn't. At that point, he was aware of it, and maybe it shouldn't have been happening the way it happened, but it's hard to tell what any person would do under those circumstances. And I think that's kind of what the assault 3 definition gets into. What would a reasonable person faced with the exact situation, what would have happened? And I think that's where assault 3 comes in and covers it with a negligent act.
So when I was looking at this issue, your proposed language is for the assault in the third degree with criminal negligence causes bodily harm to another person by means of a weapon or other instrument or thing likely to produce bodily harm. Clearly, there's no weapon, that there's been any evidence of any weapon. I don't know, I didn't see any evidence of other instrument. Instrument is defined in the Oxford Dictionary as tool or implement. I did not see a tool or implement. And then it says, or thing likely to produce bodily harm. And of course, other instrument and thing are not defined in the WIPIX, which is why I just looked up the definition of these terms in the dictionary. And thing is defined in the Oxford Dictionary as an object that one need not, cannot, or does not wish to give a specific name to. And so
I don't know if it's helpful. I apologize for interrupting the court, Your Honor. State versus Alton specifically says that your arm that is actually would constitute that or meet that definition. They do not. So as it
well, just let me stop you there. That's what I was getting at and asking Mr. Keating as to why he believes that this instruction would apply under the facts.
Let me take a look and see in just a second. Okay, I may have included a paragraph in here. There's a paragraph that says with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period of sufficient to cause considerable suffering. And I think they include, and I may have correctly put in the weapon or other instrument language. And I would agree there is no weapon or other instrument.
So your proposed instruction did specifically say by means of a weapon or other instrument or thing likely to produce. And so that is what I have is, that was on the 1 page.
Right.
Separate sheet instruction A. So now you are indicating that, what are you indicating your proposed language is then?
It would be a person commits the crime of assault in the 3rd degree when he with criminal negligence causes bodily harm to another person with, accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. And it appears that that would be consistent with what the medical records show. If we consider, I guess it depends on what a period sufficient to cause suffering is, and if it's 3 days, then, or 4 days that are noted in this case, then I think that would be appropriate.
And I do have an unpublished case that I think addresses that, Your Honor. Again, obviously it's unpublished, and so if that's helpful to the court, it's State versus Brown. State's reference is Lexus, so I apologize to the court, but it's 28. Well, I can print it and provide it to the court. But the file number is, oh, it looks like there's a Westlaw reference too, excuse me. 2018 Westlaw 4959959. And the request, that was a assault in the 2nd degree case by strangulation. The proposed request for the lesser included was with criminal negligence causes bodily harm accompanied by substantial pain that extends for a period sufficient to cause considerable suffering. So what Mr. Kading has offered here, and that is that was a Division I case. And the court there said to be entitled to an inferior degree offense instruction on this type of 3rd degree assault, the evidence must affirmatively establish Brown did not strangle Guntow that caused her bodily harm resulting in substantial pain. The court went on to identify the evidence from witnesses who testified about the strangulation. And the court essentially said that the evidence does not show that Brown committed only the inferior degree offense of 3rd degree assault to the exclusion of the greater offense of 2nd degree assault. The conclusion that he committed 3rd degree assault required the jury to selectively disbelieve parts of the victim's prior statements and her testimony. Disbelief of evidence of guilt does not satisfy the factual element of the test for an inferior degree instruction. Brown was not entitled to an instruction for 3rd degree assault. So for those reasons, I don't think it's 3rd degree is proper in this case. I would agree that the
All right. Although certainly the court is not bound by any unpublished decisions, they can be instructive to the court as the court considers different legal issues. I would like an opportunity to read this case so that I can see if it informs my decision in any way, and also I would want Mr. Kading to have an opportunity to look at that as well. And so it is 10:10, a little early, but we'll go ahead and take a recess. I know that from what Mr. Leary indicated briefly to me this morning that he has a matter with Ms. Stone, I think in another courtroom. Potentially the parties could handle that while I look at this case, and that also will give you, Mr. Kading, a chance to look at the case as well. I'm going to attempt to make this a 15-minute recess. I know the lawyers will attempt to do that as well.
Thank you, Your Honor.
I'll print out a copy of that as well.
Thank you.
All rise, court's in recess.
In the last stream, I was gonna ask you guys something, and then my mind drew a blank. I was gonna ask the paperwork that they give the defendants, like the jury. Ugh, my brain is fried. The jury instructions, the jury form, all that kind of stuff, the written stuff that they give defendants. Since they give them an interpreter, even though they speak some English, they get an interpreter to make sure they completely understand everything. Don't you think that it would only be fair that they're given the documents in their native language? I think they should. I really, really think they should. I think all of that to ensure a fair trial. Yeah, they're going over it in front of them and they're getting it translated to them. But I think cuz wouldn't they give, like, if somebody spoke English, they would get their copy in English. So why shouldn't they get it in Arabic, you know? To make sure everything is above board and they understand everything completely. I think they should. Because I think that was a question that came up about whether or not their instructions would be in Arabic or English. And I think it should be in Arabic. So nobody can say that they didn't know and they weren't informed about that question or whatever. Man, y'all, I am so bummed. Man, this week has sucked. Sucked big time. I might not stream tomorrow, y'all. I might take a day off. I know I took Monday off, but that really wasn't a day off. Because all I did Monday was sit on a stretcher and wait for them to take me to surgery. And I was there at 6 a.m. I was first case, but I was lost because of an emergency surgery. I was supposed to be in the main OR. Then, for some reason, I got rescheduled to the Women's Center OR. And that's where the emergency surgery took place. So then I got bumped. So I was sitting there all day. And then the women's surgery center closed for the day. So I got moved back to the main OR. And I was last. So I was told to be there at 6 a.m. and they wheeled me into. I looked at the clock. It was 5:01 p.m. when they wheeled me into surgery. So that was Monday. And that was the day that I found out that Malcolm Jamal Warner died. And then Tuesday, I found out that Belle has a mass in her abdomen and another tumor and might have bladder cancer on top of that. She's passing big clots. And I don't remember what day Ozzy died. And then today, Hulk Hogan died. It's been a rough week. I might just stay in bed tomorrow and bury my head under the blankets. Yeah, at the very least, read to them in their own language. They would have to, I would assume, because they can't if they are if they are giving them interpreters, then they are aware that their English is not that good. So they're aware that they need those instructions read to them, at least. I usually don't get super upset when celebrities die. And I think the fact that these three were like part of my childhood, on top of the possibility of losing my dog, I don't know. I need to go back and find that the Osbournes want to believe. I think that was on the Travel Channel, wasn't it, Judy? So it would be on Discovery Plus, which I don't have anymore, but I'll have to get it back just to watch that because that was really good. Man, to be able to go out on your own terms like that. He planned his farewell concert and everything, and he got to watch Kelly get engaged. He had all his friends and family around him. It was hilarious. It absolutely was hilarious. Ozzy was so funny. And that farewell concert that he did, that was for the fans. He didn't make any profit off of that at all. Everything was donated. Yeah, it probably was a Travel Channel. That's where I don't know why the ghost hunting shows come on the Travel Channel unless it's because people that are into the ghost hunting will want to travel there, so it's on the Travel Channel. I guess. I don't know. Um but yeah, it was good. It was so good. I love watching Jack Osborne. But I don't know. I think he has a podcast now. I've not seen him ghost hunting in a while. And I wonder if that's. Now, I don't want to get sued or anything. There's a rumor that Zach Bagans from Ghost Adventures is sabotaging everybody's ghost show and getting it taken off the Travel Channel. I don't know if it's true. That's just what everybody's saying. Well, not everybody. A lot of people. Because they're saying he wants to be the only person on the Travel Channel with a ghost hunting show. I don't know. Yeah, when you could understand what he was saying. I'm sorry, I'm not my normal cheerful, chatty self today, guys. I'm just. Man, Hulk Hogan about broke me. At least. And I know people don't like it when faith is talked about, but at least he was a Christian, so there's that. I read yesterday. Ozzy wanted on his tombstone, he wanted it to say bats taste like poop, only not poop. The S word. Bats taste like poop. I wonder if they're gonna put it on there. If I could hear it, it could be, but I can't hear it. I wish they'd use the mics. I can just barely hear them, and I'm catching very few things. I mean, what I'm catching is good, but I'm having a really hard time hearing it. I guess I could go put my earbuds in, but I'm very apathetic right now about anything. I'm just waiting for it to get over. I can go curl in a ball and cry. Yeah, he is very hard to hear. I don't know why, just because the jury's not there. They know it's being streamed. The court reporter still has to hear it. I don't know why they're not using their mics just because the jury's not there. You know, it's like when you do dress rehearsal for a play. You use the sound system, you do everything just as if the audience was full, even when there's no one there. No, I didn't. I saw. What did I see? I can't remember if it was a news break article or a thumbnail. Oh, it looks like Recovery Addict is covering. Moscow police released hundreds of BK docs. Oh, it was a court TV thumbnail. What will new court documents reveal about the Idaho student murders? That's what I read. But that doesn't say police, that says court. Wait. There's another death penalty trial going on in Florida. Scott Nelson. Who is Scott Nelson? Wow. somebody posted on Facebook in a Gen X group, Theo Huxtable, Ozzy Osbourne, Hulk Hogan, Gen X took a hit this week. Yeah, we did. Yeah, we did. Yeah, absolutely did. Oh no. Phil Collins is on hospice. Oh, look at this picture. Oh yeah, Phil Collins has been sick for a while. Yeah, he's been in bad shape. Oh, Malcolm was a year younger than me. I thought he was 2 years younger than me. A year younger than me.
in addition to the case, which was argued by Ms. Stone prior to our recess, I was also provided with State versus Coriel, 197 Washington 2nd, 397, a 2021 case by Judge Dixon from this court. I've read that now, and we'll hear any further argument. Mr. Kading, did you have an opportunity to review those?
I did have an opportunity, Your Honor, and I must admit it's a little confusing given our situation here. But it appears to me that I may have erred in adding assault in the third degree and should have added assault in the fourth degree. So it would appear to be a lesser degree of an intentional assault. So I'm going to propose it be fourth degree.
So when you are making that argument, I think one of the distinctions that I want to hear about is these cases, both cases that were cited, discuss that the charge was assault in the second degree. And therefore, they were looking at the lesser and or inferior degree charge. And it is correct that in, at least specifically in the Coriel case, the Supreme Court said that the judge erred when assault in the second degree was charged, and it was charged by strangulation, that the lesser included to that charge would be assault in the fourth degree. In this case, the charge is assault in the first degree, and so I think the differentiation as to what is a lesser included or an inferior charge is, it's the analysis to assault in the first degree, not assault in the second degree. And so that's, if that makes a difference, that is something I would like to hear argument about.
Well, Your Honor, when I read RCW 1061.003, it says upon an indictment or information of an offense, for an offense consisting of different degrees, the jury may find the defendant not guilty of the degree charged in the indictment or information and guilty of any degree inferior thereto. So I don't think that the fact that it's charged first degree limits what the inferior degree crime could be.
Then why wouldn't your assault in the third degree be the correct
Well,
lesser?
we could include it as
Under
well.
that theory.
Well, I think that one of the issues has to do with the mens rea element. I mean, it is an element of first degree, second degree, and fourth degree, but not third degree, because that's a criminal negligence standard. And I note in these cases that were cited, there was no, in Coriel, it was a second degree to fourth degree, and third degree was not included. And I think that has to do with the allegation that it was an intentional act as opposed to a negligent act.
So what, if I'm looking at Coriel, and I have it printed on pages, so I'm on page 12 of what was printed for me. I don't know if you have a printed version.
Yeah.
At footnote 50, it says, in sum, we have reaffirmed that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. To know what evidence, separate and apart from strangulation, has been presented as it relates to the issue of assault, because that goes to the court's consideration.
Well, I mean, obviously there was evidence that he did grab her, and there was evidence in the video that he was touching her and trying to move her from one point to another, which could be considered an assault for these purposes. And regarding the allegations of strangulation, I think again that's something that requires an intent, which I'm not sure has been fully.
All right, so just to be clear, you are withdrawing your instructions as it relates to assault in the third degree, and instead are requesting that in addition to the lesser included offense of assault in the second degree, which has been agreed to that there's not an objection to, and from the court's perspective, which is an appropriate instruction, you are requesting that the court give the definition or a elements instruction as a lesser included of assault in the fourth degree.
Correct, as a lesser degree of the initial charge. And I am reading in Brown where it indicates that it would be could potentially be ineffective if I did not at least ask for that to be done. So I'm asking for that to be done, and obviously that is my request.
All right. And before I hear from Ms. Stone again, Mr. Leary, this instruction does not apply to Mrs. Ali, but do you have anything that you are going to argue to the court? All right, Ms. Stone.
Thank you, Your Honor. Your Honor, I don't read either case essentially to say that once one charge has been done, we just then include every version of the lesser degree of offense. As I understand now that counsel has withdrawn the assault third request and is making the assault 4 request. As I looked at Brown and as I looked at Coriel, and to be clear, the state provided Coriel to all of the parties and the court. The workman test is the same for each. And looking at the head note 9 at paragraph 48 on Coriel, the Supreme Court there, and I would note the Supreme Court did identify that the issue becomes very confusing at times in application, even if the theory itself is relatively simplified. Implicit within Workman's reasoning is the idea that when there is affirmative evidence from which the jury can conclude that only the lesser included offense occurred, a lesser offense instruction should be given. The court goes on to say at the end of that paragraph, the test was never intended to require evidence that the greater charged crime was not committed, only that a jury faced with conflicting evidence could conclude that the prosecution had proved only the lesser or inferior crime. The reason that it was an error in Coriel to not give the assault 4 instruction is because that in that case there was an argument that one, the defendant had used self-defense or used force for the purpose of self-defense or defense of his property, or that 2, he did not actually strangle because he indicated that the evidence supported an inference that the defendant assaulted but did not strangle his girlfriend, in which case then the assault 4 instruction became appropriate. That does not appear to be the case here, so it's, I guess, confusing to the state why the assault 4 would be appropriate in this case, separate and apart from the assault 2 instruction as it relates to that. I don't think that we just continue to add, and I don't think Workman or Brown or Coriel stand for the proposition that we just continue to add lesser offenses.
Because he assaulted Isaiah.
So I don't know that assault 4 is appropriate in this case either, based on the facts that we have, but I do believe assault 2 would be appropriate as a lesser included offense.
The lesser included is for the assault on Isaiah, right?
I was looking also at paragraph 45, and just some of these statements that were made from the Workman line of cases. Quote from Gallagher, a defendant may not be convicted of a lesser degree of a crime which is included in a greater degree unless evidence is adduced to sustain a conviction upon the lesser degree. And the quote from Foley, the lesser degree of crime must be submitted to the jury along with the greater degree unless the evidence positively excludes any inference that the lesser crime was committed. It also talks about at paragraph 43 how we've arrived at lesser included offenses under the English common law. So second sentence of that, the common law rule existed to aid the prosecution when the evidence introduced at trial failed to establish an element of the crime charged. So let's say you had theft in the second degree charged, and then at testimony, instead of it being $750, somebody only testified as to $500. In that case, it would be appropriate. And I don't think that that is what we have in this case. So I don't think those are appropriate in this case as to assault 3 and assault 4.
All right, well, the assault 3 instructions have been withdrawn and will not be given. So the issue is whether or not an assault in the 4th degree is a lesser degree offense of assault in the 1st degree under the facts of this case. And I think that Coriel is the better case in its discussion, and of course it's a published case, than the Brown case, and attempted to be more clear than the Brown case as well.
Coriel is also a 2021, so it's post-Brown, and Brown did rely on that Fernandez, Medina, I believe, language that Coriel was trying to clarify as well, Your Honor.
Correct? And the test that the court is to use when giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction is given. And of course, that evidence can come from any source. It doesn't have to be from a defendant testifying, and it can include evidence presented through questions on cross-examination or evidence that is presented by the state. Ms. Stone, as it relates to Mr. Kading's argument that there is affirmative evidence that would establish assault in the 4th degree, as it relates to what was on the video of Mr. Ali grabbing Fatima and then chasing after her. He had her when she was bent over and is grabbing her in some fashion prior to any evidence of strangulation. And that's what I heard Mr. Kading was basing his argument that is evidence that would affirmatively establish, I guess, the theory that this was an assault, potentially was an assault in the 4th degree instead of assault in the 1st degree.
Well, I think for that to occur, that would have, for that argument to fit the case law as we have it, it would have to essentially account as 2 separate assaults. As it did in Coriel. Coriel case talked about there essentially being 2 assaults that were occurring instead of 1 ongoing. In this case, it's 1 ongoing assault. So I don't think you can argue that in the process of going to strangle someone, the second that you have grabbed them for the purpose of strangling them, then you are entitled to an assault force instruction as if that is a separate incident from the entirety of the strangulation itself. And so I don't think that argument is consistent with the case law. If counsel is arguing that there is a separate assault, that essentially the first time his client grabs his daughter is the assault for, and that is an appropriate instruction for that incident itself as it's separate and apart, then I would agree with that assertion in terms of a lesser included offense, but that it did not apply to, in that case, the second grabbing of Fatima and taking her to the ground. I would not agree that the assault for applies based on that set of facts.
Will you state that again?
Yes, Your Honor. So when we are looking at the video, there is the initial contact with Fatima where Mr. Ali is described as aggressively grabbing Fatima, and that is when Isaiah tries to defend Fatima and separate Mr. Ali from Fatima. As you see in the video, Fatima falls down and she's attempting to run away, and Mr. Ali turns and punches while Isaiah is then flying backwards. Mr. Ali goes after Fatima again and puts his hands on Fatima, and then they start to go to the ground, and that is where the strangulation occurs. If Mr. Kading's argument is that the assault for is appropriate based on that initial grabbing of Fatima where Isaiah, then I think that is appropriate. If that assault for request is based on the moment he puts his hands on his daughter to begin strangling her, that the strangulation has not yet happened, and that assault for is essentially the initial touching and it has not yet developed into the strangulation, then I don't think that is appropriate. When we're talking about Coriel, the facts in Coriel is that there were essentially two separate assaults that occurred, and the court said as it related to this other argument, the court could have determined that these markings on the victim's neck in that case came from something else and not as a result of the incident where the victim described being strangled, that there were essentially two separate. In our case, the state is arguing that this is a common scheme or plan and that there are not two separate incidents. If that is Mr. Kading's argument, then I would agree that he would have a an argument for assault in the fourth degree as a lesser included, if that initial contact is what he is referring to, but not if he is saying it is at the start of essentially the second contact and therefore he's entitled to that, because certainly it goes well beyond that. He doesn't simply touch her and walk away from that. So I don't think assault for in that case is appropriate.
Mr. Kading?
I have no response, Your Honor. Thank you.
All right. All right. Based upon my reading of State versus Coriel, in that case, the Judge Dixon, who's pictured here in our courtroom, was reversed. It was a case where the charge was assault in the second degree. Defense offered an assault in the fourth degree charge. And in an opinion that they said was to help clarify the law, it still continues to be somewhat, not trying to impugn this decision, but it is not, frankly, still completely clear. And I think that that is clear from also what the lawyers argued, that it's not clear necessarily. But the very last paragraph of this decision under, right before section C, and it is at paragraph 50, it says that in this case, they are reaffirming that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. It's not my job to weigh the evidence or to indicate, as I put together the jury instructions, how the court thinks the evidence has been presented. In this case, I do believe that there has been some evidence that has been presented that affirmatively establishes a theory of assault in the 4th degree. After reading the Coriel case, and therefore I will give that as another instruction for a lesser crime. So I want to go back to instruction number 22 on the packet. I am going in the first paragraph.
And I know the court is looking at that now. The state had, only tried to find it last night and could not, that if the court was doing it for 2 lesser crimes, whether it should be the lesser crimes of assault in the 2nd degree, and then whether it should be an and or an or. I plainly couldn't find that, and I was concerned there might be confusion as to that. So the request of the state was going to be to essentially restate that first paragraph a second time without that first sentence, so that it is very clear. So it would read the first paragraph as it says, the defendant is guilty of the lesser crime of assault in the 2nd degree if, after full and careful deliberation on the charge of assault in the 2nd degree, you are not satisfied beyond a reasonable doubt that the defendant is guilty, then you will consider whether the defendant is guilty of the lesser crime of assault in the 4th degree. So just essentially restating that to not run into that issue of whether an and or an or confuses the jury as to application. And then the 3rd paragraph would remain the same.
Mr. Keating?
Your Honor, I would not object to that, but I will defer to the court.
All right. That proposal seems appropriate to me, and I think will be the least confusing, will be as clear as possible for the jury as it relates to their analysis. All right. Instruction number 23. That is 23 and 23A. Those are that's the definition of assault in the 2nd degree. And I just want to indicate that I am incorrect in the note that I wrote. The assault in the 2nd degree under WIPIC 35.10 would, except we're using 23A, correct? I apologize. We already, I heard about that before I started the, I believe that there was an agreement to 23A for the definition of assault in the 2nd degree.
Yes, I agree that that would be correct for 23A. If we're going back to 23 regarding strangulation specifically.
But then I don't have to, oh, just a moment, I apologize.
Yes, Your Honor.
I think that instruction 23A addresses both.
Yes.
And so I don't need to get to instruction 23, but I was incorrect about the word intentionally. I indicated in my note on 23 that it was part of the WIPIC, but it is not for the strangulation prong.
Yes, Your Honor. So agreement on 23A, if we're leaving that as it's written.
All right, and then now, Mr. Leary, you can make your argument about the word intentionally.
The other problem is that my client is not charged with recklessly inflicting substantial bodily harm.
That's correct, and it's not in part of the elements instruction either for her. The only thing in the elements instruction for Mrs. Ali is the strangulation.
Right, so I guess if we're giving 23A, we make it clear that it only applies to Mr. Ali.
No, that's the definition of assault in the second degree. It can happen in one way, or it can happen in the other way, and it's the elements instruction that tells the jury what the state has to prove as to each defendant. And it only addresses strangulation as it relates to Mrs. Ali.
So I haven't done a lot of co-defendant trials, so this is kind of why I'm just pausing, because my concern is that the definition of assault in the second degree that includes recklessly inflicts substantial bodily harm, I understand why it's being given as the lesser for the assault in the first degree, but we would never include that. If I'm standing here alone, that language wouldn't be in the definition because it's not charged for my client. And so I understand what the court is saying is to convict my client. I don't know that I'm wrong, but I just have this concern that the definition to the jury for assault in the second degree includes an alternative that my client is not charged with.
The definition defines assault in the second degree, and it indicates that for the purposes of this trial, that assault in the second degree is defined in two different ways. The elements instruction is clear as to how Mrs. Ali is charged. She's not charged, or it's not, the state does not, could not prove that she committed assault in the second degree if she intentionally assaulted another and recklessly inflicted substantial bodily harm, because that's not part of the elements in the elements instruction. But Ms. Stone?
I agree with that, Your Honor. I think the word "or" there is specifically for that purpose, and when we get to the to convict, which is what the jury has to determine the state has proven or disproven beyond a reasonable doubt, that addresses that issue for Mrs. Ali.
And so the 23, so the issue is to the word intentionally.
Yes.
So instruction 23 pertains to WIPIC 3510, which does not include the word intentionally.
Correct.
However, if you go to the to convict,
Right?
35.19.01, it does include the word intentionally, and so I requested that those two are consistent, and thus I included the word intentionally assault, even though it's not in the WIPIC as currently formulated.
All right. And that is what, I would indicate that I did understand that when I reviewed your instructions between them. But Ms. Stone,
It feels redundant because that instruction or that word is in assault already that they will have just, I think, been instructed on. I don't know that it particularly matters, but the WIPIC didn't include it, and I assume that that is why, since it is included in the assault definition itself. So it feels redundant.
all right. I am not going to add the word intentionally to 23A. After the "or," it would be, the request is that I put the word intentionally there, intentionally assaults another by strangulation. That is not in the pattern instruction. I don't have to give the pattern instruction, but there's not going to be any confusion. The definition of assault is contained herein, and the elements instruction includes the word intent or intentional. There's not going to be any confusion, and will use the pattern instruction. Any issue with number 24, Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
25 and 26, any issues with those, Ms. Stone?
No, Your Honor.
Mr.
No,
Kading?
Your Honor.
Mr. Leary?
No, Your Honor.
All right, on number 27, the proposed instruction from Mr. Kading, just a moment here. Let me- Not sure which packet that came in. Well, I think I added the language of the lesser included crime of assault in the second degree. I believe that I added that. I didn't know if that was appropriate or not. I couldn't find the WIPIC that might apply to that.
And I think it's I'm looking at the courts, I think it indicated instruction number 27 state, I don't think the state.
No,
proposed-
it's not. It's
Oh,
not a
okay.
state proposed rule.
27A then, if we're looking at that, essentially instead, I think that is the modified 35, with the 3512 and 3519.01. I don't have, oh, I'm sorry. We talked about it last night. I think the state would be requesting, as it is the alternative means for Mr. Ali. First of all, obviously Fatima's name would be Fatima Ali, and that change would be made. So it would be 27A using the affirmative, or excuse me, the alternative means, but I think it should be modified in this way instead. Each of the following elements of the crime must be proved beyond a reasonable doubt. One, that on or about October 18th, 2024, the defendant, comma, it should be then two, that the defendant intentionally assaulted, sorry, I'm backing up. On or about October 18th, the defendant, on or about October 18th, 2024, semicolon, 1A, intentionally assaulted Fatima Ali and thereby recklessly inflicted substantial bodily harm, or B, intentionally assaulted Fatima Ali by strangulation, semicolon, and 2, that this act occurred in the state of Washington. If you find from the evidence that element 2 and either element 1A or 1B have been proved beyond a reasonable doubt, and then the rest of the language is the same as to element 1A and 1B.
Can you print that out?
Yes, Your Honor.
And I want to make sure that I understand the proposed language. And I should have said, can you print that out, please?
I understand.
Okay.
Thank you.
All right, so I'm going to come back to that instruction. All right, number 28 is the elements instruction for assault in the second degree as charged for Mrs. Ali.
Just the name change from the state, Your Honor, or the name spelling out from the state.
So you agree that the word intentionally should be included?
Yes, Your Honor, and it is
Okay.
listed that way in the book.
Yes, okay. Any issue then with 28, Mr. Kading,
No, Your Honor.
Mr. Leary?
With the inclusion of intentionally, the change to Fatima Ali, no.
Okay. All right. Next is instruction T9, which is the definition of unlawful imprisonment, which is WIPIC 39.15, and whether or not the language without legal authority is properly included in this instruction.
This is the
objection from the
longest
state, yeah, I think
charging
that is
conference
All right.
ever.
No objection from me either.
I mean, she's
So
being very thorough,
that
but
will be used.
long.
Any issues with 30 or 31? Ms. Stone?
No, Your Honor.
Mr. Kading?
No, Your Honor.
Mr. Leary?
No, Your Honor.
32 and 33 are the elements instructions on unlawful imprisonment for both Mr. Ali and Mrs. Ali. The difference between the state's instruction and each of the defendant's instruction is what I included in here as paragraph 5. And then at the top, it would be whether or not there's 5 or 6 elements. Ms. Stone?
I would leave the state, changing, Fatima Ali's names in, both 32 and, 33. And the principal or accomplice language is, charged in each of those cases as well. And so I think the principal or accomplice language should be included on elements 1.
All right, and any objection to paragraph, or number 5?
One moment, Your Honor, please. I made a note and now I'm trying to understand my note. I guess I was, in terms of element 5, I had a question as to if we know from that the authority, when you are restraining a child in the manner in which it was restrained, is not legal. So I guess that's my question, what the intent is for defense counsel's version of it. If the argument is going to be that they had the authority to do so in that manner, that they believed they had the authority to do so in that manner, which to the state would be a jury nullification argument. So I guess my question is, why is element 5 being proposed when that is without legal authority to do so in the manner in which it was done?
Mr. Kading?
Well, Your Honor, it appears that the knowledge element would be important to include here, since it's obviously an element that regarding parents. If the state argues that the restraint was without legal authority, that's something they have to prove. They should have to prove that the defendant knew also that they did have no legal authority to do that.
Mr. Leary?
So the note on use says that element 5 should be used when facts exist to suggest that the defendant had a good faith belief that he or she has a legal authority. So parents would certainly fall within that category as to having the legal authority and whether or not their actions exceeded their legal authority as parents. And so the knowledge element.
No, you don't have
should be
authority as
included
parents to
based on
choke
the
your
comment
kids.
and the note on use and the case law.
So since you're talking about the case law, I looked at Warfield and Johnson related to this issue, and the cases indicate that the knowledge prong, this paragraph or this sentence would only be used where the defendants had a good faith belief that they had legal authority to imprison a person. And in the Warfield case, it was the bounty hunters who picked somebody up on an out-of-state warrant, and they believed that the warrant would have been enforceable here in Washington, but it was only a misdemeanor warrant. And so it wasn't, and they were charged with unlawful imprisonment, they were given, or should have been given this instruction, because they had a good faith belief that in fact they had the ability to take this Warfield, or the person that they had come to Washington State to get, they had the ability to take that person and return them to Arizona. And Johnson, in talking about Warfield, says that Warfield is unique and does not apply to most unlawful imprisonment cases, where there is no indication the defendant believed they actually had the authority to imprison the alleged victim. You wouldn't get number 5. And so is it your argument that because Mr. and Mrs. Ali are parents to Fatima, that they believed that they could restrain her in any fashion?
Not that in any
No.
fashion, but that they had the legal authority. So specifically to the acts of my client, she had the legal authority to restrain her runaway daughter in the fashion in which she did. And that the state has to disprove that she was acting with knowledge that the restraint was without legal authority.
All right, Mr. Katie?
Your Honor, I would concur with that the parents obviously have the right to restrain their children to a certain degree. If the degree is not met, then that's the state's argument regarding why it was unlawful. So I would ask that this be included.
Ms. Stone?
Yes, Your Honor, so even by the information cited by Mr. Leary, there has to be evidence of a good faith belief. Status as parents does not create evidence of a good faith belief. There's been no testimony, there's been no indication of that in this case. Both Mr. Ali and Mrs. Ali strangled their child. That is outside the bounds. And so insofar as at least the state, and maybe it is over interpreting Mr. Leary's argument that his client believed she was able to do so in the manner in which she did. I don't know if that is intended to branch out at closing into some sort of argument of what was the norm in their household, what is a culturally accepted, or something else. Those would be inappropriate. It essentially appears to argue that, well, their ignorance of the law made it okay, and the state can't prove that they didn't have ignorance of the law, and that they decided that was a good faith belief, and there's no standard essentially provided to the jury about what a good faith belief is. So I don't think it's appropriate in this case. The manner in which they restrained her is not legally appropriate, and it is without legal authority. It doesn't prevent defense counsel from making the same argument, but that good faith belief language appears to be provided minimally and rarely at best. And in this case, the jury can make that decision based on the parental discipline instruction that I believe Mr. Leary may have proposed it as well, Mr. Kading proposed it. And that provides that information for the jury to decide whether they were acting within or without legal authority versus whether they had a good faith belief to act as they wanted to. So I don't think element 5 applies in this case.
All right. So I think I alluded to this yesterday when I was ruling on Mr. Kading's motion, I think, to dismiss the unlawful imprisonment charge. This is actually an issue that I have been thinking about as I've gone through the instructions. As I indicated, I read the cases that are cited in the WIPIC, specifically addressing this issue, and that is whether or not included in the elements instruction would be that the defendant knew that such restraint was without legal authority. And I referenced at that time the instruction 21, which is the defense to assault, that the force used was lawful related to discipline of a child, and that instruction specifically talks about that the jury may, but is not required to infer that it is unreasonable to do any of the following acts to correct or restrain a child. And that is because parents have the right, constitutional right to parent. Kids have no rights, basically, frankly, as it relates to that constitutional right, and parents' right to parent their children how they want to. Now, it can't be abusive, but parents have a great latitude to parent, and kids have no right, they don't have right to good parents. And that's why I say that kids have like no rights. But that's the state of the law, that's the state of our Constitution, and the freedoms that are provided to adults who have children. And I believe it would be inconsistent for me not to include number 5, since I have given the instruction about the discipline instruction. I do think that even though they are different and apply to different things, they are related. And there was no indication that I'm just giving this as an example, that Mr. Ali believed that he had a basis to, I'll stop there. I think these instructions are, that one sentence and that other instruction are related in some fashion. It would be inconsistent for me to not include number 5 because the parents do have the legal authority to restrain children. The issue in this case, of course, is whether or not that was an appropriate restraint. And that's for the jury to address. So I am going to include number 5.
Thank you, Your Honor. I would ask, though, to confirm prior to closing and ask the court to prohibit any argument that would essentially be a jury nullification argument to the jury at closing, that these two parents in particular, based on their personal beliefs, had a good faith belief that that was okay, as if somehow in violation of the laws, acting within the own scope of what they believe is okay, somehow that it's essentially a moral relativism argument. We can do what we want based on what we think is okay, even if that is inconsistent, and that somehow that then therefore qualifies as a good faith belief. I don't think that is appropriate. I also think that is, as I said, I think it would be a jury nullification argument. I also think it brings in cultural norms that are not appropriate in this case, and we've worked very hard to try and keep those arguments out from the jury so that they are making appropriate decisions.
All right, well, there's been no evidence presented at all related to cultural norms in this family except what Fatima testified to. And so there can't be any argument that infers facts that aren't before the jury. And so I would think that neither Mr. Cady nor Mr. Leary are intending to make arguments for facts that are not in the record, or a reasonable inference from a fact that is in the record. Is that correct, Mr. Cady?
Yes, Your Honor.
Mr. Leary?
We certainly do intend to explore the concept of implied bias when establishing and evaluating credibility, which, in terms of how my client is perceived, not her values justify what she did, but in terms of evaluating the evidence and talking about the instruction on implied bias.
All right, well, then I will take up objections during closing argument if the state believes that Mr. Leary is arguing something that is not supported by the facts that are in the record.
Yes, Your Honor, thank you. And I think, was the court including the principal or accomplice language after defendant? I think I said it, but then we started talking about element 5, and I don't recall where we ended on that.
Thank you. Yeah, I have it as you said that, I wrote that into these instructions. Mr. Kading, any objection as it relates to number 32, adding the language as a principal or as an accomplice?
Again, as to the to convict instruction for Mr. Ali, I'm not sure that that's, I mean, is there an allegation that he was somehow involved with Mrs. Ali? Again, I think that this is a situation where she came in after he was no longer involved.
I mean, I don't actually think that that's, I know that that is defense counsel's argument to the jury. I don't think that's consistent with the state's theory of the case. It's also not consistent with the video. She is actually there while he is choking his daughter. So I certainly don't think it hurts, it prejudices the defendant in that case. The state's ability to prove it is the same based on the evidence either way.
All right, Mr. Leary?
I don't believe the court gave the accomplice instruction for Mr. Ali on the attempted murder. I don't see how this is different.
And as to Mrs. Ali?
As to instruction 33, based on the court's prior ruling on accomplice, I think the language is appropriate.
All right.
Maintaining my theory.
All right. So as to Mr. Ali, as to instruction 32, I am not going to give as principal or as an accomplice. I don't believe that there, even with the inference to, and most favorable to the state as to the evidence that's been presented, that Mr. Ali was an accomplice to anything that Mrs. Ali ultimately did after he was no longer restraining, strangling, whatever word you want to use, Fatima, once he finally released her, once the bystander was able to get him to release her, I don't believe there's any evidence as to any interaction that he had with Mrs. Ali at that point, or until much later. So I won't include the language there, but I am going to include it in 33 as it is appropriate for the reasons I've already articulated. Any issue with 34 or, well, any issue with 34?
No, Your Honor.
All right. So the definition on number 35 is going to,
So
Be
she's not an
moved.
accomplice on the strangulation, on the attempted murder?
to earlier, as it relates to the inferior
So she's not being charged with the attempted murder?
matter. So number 36,
Just dad is getting charged with attempted murder?
No issue on 36, Your Honor.
except that I need to identify that that applies,
You want to put that as to count 4?
yes.
Okay, I don't object. However we want to word that, count 4.
So I'm going to syndicate. It is a defense to a charge of assault in the 4th degree as charged in count 4, that the force used was lawful.
And does it need to say charged in count 4 against Mr. Ali, or do we need to, since there's 2 count 4s?
Yeah, it's the same thing.
Do you believe that it needs to say as charged in count 4 as to Mr. Ali?
I don't think it hurts, Your Honor. I think it's
Okay.
clarifying.
I will add that the only count 4 of assault in the 4th degree is to Mr. Ali, but I do want the instructions to be as clear as possible. With that addition, the state's already indicated no issue, and Mr. Kading, no
Okay.
issue. Anything from you, Mr. Larry, on that one? All
I
right.
do think the state is going to be requesting, though, if the court gives 36, the state is requesting that 1604, first aggressor be provided instruction as well.
Wow, there's not hardly anybody there, but Isaiah's dad is there.
Do you have that instruction?
I don't understand why they're not being charged with Isaiah's assault too.
And you can come back to that then.
All right.
If I was Isaiah's dad, I would
Also,
be like,
just for
you need
the
to put that in there too.
parties
I would
information
flip
as it relates to these
Nobody
instructions
punches
that
my
we're looking
kid.
at right now.
Nobody.
I have number 37 as the
Yeah, Jeanette, I am so sad for this
instruction
girl. Oh my gosh, I can't
related to no
imagine.
duty to retreat. And then I have the necessary instruction in 38. I actually would give the necessary instruction. It will be moved up. It'll be before the, whether or not there's a duty to retreat if I give both of those instructions. Certainly I'll give the necessary instruction. And that was just my error in not having that be first. Any issue with number 38? Ms. Stone?
No objection.
For your instructions, Mr. Katie, no issue. On number 39, Ms. Stone, are you requesting that I continue to use initials?
I'm not, Your Honor, I'm asking that you use Mr. Williams' name in that.
Yep, yes.
But they're
Any
not
objection,
allowed to-
Mr. Kading, just to changing that instruction only as to listing the name of the alleged victim instead of initials and removing?
Oh, just for the victim, okay. So because they didn't put on a defense,
Ms.
they're not allowed to
Stone,
argue
any
that it
issue
was
with 40,
just
41, 42, 43?
No, Your Honor, none.
Mr. Kading?
No.
Mr. Larry?
Take issue with 41.
It's a slam dunk. They should have just,
6503.
they should have taken
Actually applies to the facts in this case.
they
I
should
think
have
that
taken
pertains
a
to,
plea.
the note on use says, do not use this instruction in the usual case.
Because if they didn't even put on a defense, so they can't
Parks,
even
like someone
argue
breaks a
that it
window and
was
sticks a
just
hand in,
normal discipline,
Is that
which we
constitute
all know
entry
that's not normal
or
discipline.
burglary?
But they
Here we're
can't even
talking about
argue that.
her presence on the entire Timberland High School property.
Ms. Stone?
I don't think it hurts to have it. I would, agree that following or the insertion of any part of the person's body, we could end it there with a period and the remaining.
Oh yeah, Jeanette, earlier I suggested that they should have had somebody testify that went with along with their religious beliefs, and I got roasted. I'm just saying they need to say something in their own defense. But no, nothing. Nothing. Absolutely nothing. So there's not even so in their closing, they can't even argue. Like, what are they going to argue? They didn't put any evidence forth. They didn't put any evidence. So they can't argue things that aren't in evidence. So they can't say it was discipline or what are they going to argue? They can't argue anything because there's nothing in evidence to argue.
Clause would not need to be, the clauses would not need to be included.
All right, I did not look at that, I didn't print that particular instruction as it relates to the WIPIC. And so I want to look at that. So I'm going to have to come back to that one.
So no objections to 42. And then the court also asked me about 43.
That's correct.
Okay, I do have an objection.
And I'm certainly not defending them. I am certainly not defending them. I'm just saying why even go to trial if you're not going to put on a defense?
For that. So that is WIPIC 60.05, the inference instruction. Particularly the facts in this case. I think inference, note on use, the WIPIC committee says use caution in giving this instruction, see comment below. They talk about the concern about inference instructions generally. I think there's a particular concern by the defense for Mrs. Ali about the court telling the jury that they can infer that she acted with the intent to commit the crime against the person or property therein, particularly when there's a mixed motive here. The state's allegation is that the burglary charge gives rise from her unlawful entry or remaining at the school with the intent to violate the protection order. There's also an equally alternative explanation, which is why she was there, was to see her daughter, recover her daughter, and protect her daughter. And so, obviously, the state can argue to the contrary. I can argue my position, but I think particularly in this case, the inference instruction is improper.
Ms. Stone?
I disagree, Your Honor. I note that counsel makes that argument after modifying the to convict instruction under 46 to try and say that the state essentially must prove and add an additional element of proof to the state, which is not required by law or by statute. The state need not elect any. I think there's a number of arguments as to what crime she could be doing. First of all, she's violating the no contact order. She knows exactly where Isaiah has run. Assaulting Isaiah. She's already described an interaction with Isaiah. Re-assaulting her daughter. Re-restraining her daughter.
Hey, Jill. Where'd the sound go?
Also, I printed out and read many of the WIPICs involved in the different charges that are before the court, anticipating different arguments that I thought I would hear. I did not anticipate this argument. I have not read this WIPIC. I also optimistically thought we would conclude instructions before our noon break, and we are not going to, so that'll give me time to look at the WIPIC on both instruction 41 and 43 before I rule on those issues. Number 44.
State agrees we don't need it.
All right, so that's instruction is withdrawn. Any issue with 45, Ms. Stone?
No, Your Honor.
Mr. Kading?
Nope.
Mr. Leary? All right. 46 is the elements instruction regarding the burglary in the second degree. The difference, I believe, between the two offered instructions, one from the state, one from Mrs. Ali, was that you have included the specific crime of violation of a court order. Mr. Leary, I'm going to go ahead and let you argue on that.
So I do believe I put in my trial memo that I had a question as to what was the specific underlying crime that my client was alleged to intending to commit. I did have a conversation with Ms. Stone. She indicated to me that it was violation of the protection order. If there are other crimes, then I would make a motion for a bill of particulars as to what crime, and then the question is going to be is whether or not the current jury instructions adequately inform the jury as to what crimes there are. And so I want it to be really, I want to know so that I can articulate and describe why my client, it's two parts: enter or remain unlawfully with the intent to commit a crime. And I think I'm entitled to notice as to what crime the state is alleging my client intended to commit as a part of the burglary. If it's beyond the protection order, I think I want to know what it is, and I want to make sure that the jury is properly instructed as to
Okay, well, both.
all of the crimes that the state
Trespassing and
is
the
going
TPO.
to use to argue that my client committed burglary.
Ms. Stone?
Your Honor, when we had that conversation, Mr. Leary offered me a number of options. I said, yes, no contact order, a reassault of Isaiah, or with all due respect to Mr. Leary, I characterize the response to that as poo-pooing some of those options as he disbelieves them, but the state clearly articulated that. We are at the end of trial. I just gave a number of indications of crimes that could be provided. The case law is very clear that that is not an element for the state to prove at trial in a burglary. I have provided now multiple times an indication of arguments the state will make as to what those crimes are. I understand that Mr. Leary disagrees with those on behalf of his client, but those, plainly you cannot add elements for the state to prove that are not required by either statute or case law. That is what counsel is intending to do here. It is not appropriate to put that in the to convict instruction because it is not in fact an element. And when we go to argue that to the jury should expressly know that that is not an element. And Mr. Leary cannot argue that the state has to prove that. The jury does not have to elect which of those it is. The jury has to believe, and that is why the inference language in the prior WIPIC exists in the first place. So it is improper.
This is the most
to add that as an element.
contentious.
There is not a bill of
This is the most contentious charging conference I've ever seen. Usually, and I think that's why it's been so long, because usually they just stipulate on the majority of the wording, and this whole case has been a train wreck.
particulars at this stage of the case to provide to counsel that I have not already provided in the argument as we have sat here.
So I would just, I'm sure as the court reviews, the court will see note on use. It may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests. That's in the WIPIC 46004. So that's the basis for the request.
She wasn't supposed to be on
What's
campus.
I'm sorry, which WIPIC are you looking at?
So I'm looking at the to convict WIPIC for burglary in the second
Yeah,
degree.
16.04?
She was
Yes,
violating
16.04.
a protective order
Which is instruction 46.
Yes.
because she had assaulted Isaiah. Well, those are two crimes she was committing. No, they haven't done closing arguments yet. They're gonna do that on Monday, Jill. I don't know why we're not doing them tomorrow. I guess she's giving them tomorrow to work on closing arguments, and then they're gonna do them on Monday.
What did you say the language says here?
So note on use?
Yes.
It says, under some circumstances, it may be necessary to specify and define the crime alleged to have been intended by the defendant if the defendant so requests.
And then it says burglary in the first degree elements.
It says, see comment, WIPIC 6002, burglary in the first degree elements.
And then when you go down further to comments, under crime against a person or property, ordinarily, the jury instructions need not specify the crime that the defendant intended to commit inside the burglarized premises. As an exception, that crime must be specified if it is material to the defendant's theory of case. Applying Bergeron, the Court of Appeals has held the jury instruction in a burglary case should not include the elements, even if the defendant has asserted a good faith claim. And then it goes on to say there is no statutory definition of what constitutes that crime. The Washington courts have construed the requirement with a, quote, common sense, end quote, view of the underlying purpose of the statutes to prohibit and punish conduct creating a risk of or actual harm to persons of property within a building. I have now provided that to defense counsel, again, multiple times. It is not required within the statute. It is not an additional element. The state has to prove at trial that the underlying crime has either in fact been committed, or for the jury to elect which of those possibilities that they believe could have happened, or she was intending to go in, does not have to elect between those possibilities of behavior. So I do not think it is appropriate.
All right, and I also do have that instruction in front of me, and I thought I heard you say something different, Mr. Lair, which is why I had you repeat what you said. I'm going to use the instruction as proposed by the state. The WIPIC does not require, nor do these circumstances require that the court specifically indicate the language that was proposed by Mrs. Ali, that entering or remaining was with intent to commit the crime of violation of a court order, and I will not include that language. The instruction as was proposed by the state is a correct statement of the elements that need to be proven for the, that's the burden on the state.
But see, this is the problem. They didn't put a defense on. So they can't argue anything that's not in evidence. They didn't put any evidence up. So what are they going to argue in their closing? So what was it a while ago? They were talking about the argument that he was just disciplining his daughter. Well, they can't argue that because there was no testimony to the fact that he was just disciplining his daughter, which we know that's BS anyway, but there was no testimony to that fact. So they can't say it in closing because that's facts not in evidence, because it wasn't testified to. So what are they going to say in closing? Like, what? I don't understand the strategy of the law. I don't get it. I just don't get it.
Number 47, any issue with 47, Ms. Stone?
It should have I think we have restraint provisions language should be coming after provision of the order. Can we come back to 47 and 48? We modified the language on that and we're going to resubmit that. So we'll provide those to the court.
Okay. All right. Actually, we're gonna start, it's noon, or it's a minute to noon. So we will come back and address the additional instructions. Mr. Kading, since you are now offering an assault in the 4th degree as a lesser charge, I need you to provide over the lunch hour the elements as to that lesser charge. I already have the definition because the definition's already been previously provided, as well as a proposed verdict form, since you are proposing those instructions, and I don't have those.
And I do think Ms. So provided the initial request for those lesser included. That may be in the packet that she handed up to the court just a few minutes ago. So, and I think it went to both Mr. Larry and Mr. Kading as well. It's just a hard copy that Ms. Lou just provided.
I see.
The verdict form would not have been in there though.
All right.
We need a verdict form for the lesser included assault 4. Right?
That's what you're offering, right?
Yes.
Okay.
I'm just trying to make sure that I got it.
I don't want to create instructions. I want to use the instructions that the parties have submitted. They may be changed, but the court does not want to create the instructions.
I know we're not talking about 151, but the only question I had at the outset, and I think we'll just need to flesh that out, is whether we had enough letters for lesser included based on the number of lesser included that we're going to be giving.
Right, that's going to have to be modified based upon, I created the concluding instruction with one lesser included, because at the time I created that addition within that instruction, the only lesser crime was the assault in the second degree.
And I do think you had indicated, Your Honor, to delete the special verdict form, but I do think we need the special verdict form.
I added that language later on, which is, so look at the entire instruction, that's why I thought it should be deleted there, because it's included further down in the instruction.
Thank you, Your Honor.
All right, so we will be in recess until 1:30, and then we will take this back up. Mr. Leary?
I think there's one instruction left, but I don't think it's gonna be in disagreement, so I don't know if we wanna hammer it out now, or not.
No.
I don't know.
I also need to look at the two whippets that I talked about under the burglary charge. And this also gives me an opportunity to hopefully make changes that we have discussed as well, in case I have any questions as I'm making those changes to ensure that I haven't missed anything. So the court will be in recess until 1:30. Thank you.
All rise, court's in recess.
I didn't see it because it was in California and they don't stream trials in California, but it was the Danny Masterson case when he raped those women. The actor Danny Masterson, his first trial, they did not put on a defense, and the first trial ended in a hung jury. And then his second trial, I think they put on a defense the second trial. I don't remember. But then he was found guilty the second trial. And I want to say there was a trial recently. I don't know if it was one that I covered or if it was just one that's been pretty recent that they didn't put on a defense. I can't remember. But the defense doesn't have to put on a defense because they have no burden of proof. Yeah, they didn't televise Masterson. Because the prosecution has the burden of proof. So if the defense doesn't think that the prosecution proved anything, they don't have to put anybody on the stand if they don't want to. Was it Lori Vallow? I was thinking it was Lori Vallow. I was thinking that's who it was. Because I was thinking it was a more recent trial, and it was one that I didn't cover. I think it was Lori Vallow. But yeah, they don't have to. I still would though. Like if I was a defense attorney or a defense client, I would still want to put on a defense. Whether I thought, no matter how good the prosecution's case or how bad, I still would want a defense. Because I didn't even think about that until the judge said that. How are you going to argue a closing argument when if it's not... I didn't watch either. I watched like highlights. I didn't watch the whole trial because that woman just disgusts me. Anyone that uses religion as an excuse to do such horrible things, I don't want any part of that. But I never thought about that before because you can only argue things that were in evidence. So if you don't put on any evidence, how are you going to argue? How are you going to argue anything if you don't have evidence to the contrary of what the prosecution is saying? How do you put forth a closing argument? I never thought about that before. So this ought to be interesting. Now I really wish they were doing it tomorrow instead of waiting until Monday. Because this is going to be, because you know how like opening statements aren't argument, they're a statement, and they get up there and they say the evidence will show, or you will see this, well, they kind of said, well, dads, because we've got two, because we've got joint defendants, so dad's attorney said basically that what is shown on the video and what the people are going to tell you are two totally different things. That's basically what he said in opening statements. Well, no, this one has been. She just is giving them tomorrow off for some reason. But maybe she has something else tomorrow. I don't know. But we didn't get to see the videotape because of the minors, but I have watched it because you can find it on YouTube. So from what I've seen, and what they didn't let us watch the kids testify, but we could hear them. So what they said and what I saw matches pretty good. So I don't think what the attorney said is true. I thought he would have someone medical like look at the video and say this is how it happened, because he keeps saying, and he would ask witnesses questions about it, like the medical witnesses, because she developed, see if I can remember what it's called, pneumomediastinum. It's where you get air comes out of your lungs and goes into the space in here that's not like outside of your lungs. And he is saying it develops. And the fact that he knew this, I figured he has a witness that has told him this. So he's going to put that witness on the stand. But no, they didn't. He says because when your air is blocked and then you hit the ground, your lungs pop like a balloon, and that the air makes the air escape from some point in your lungs, and the air goes into the cavity around it. So I'm like, okay, he's a lawyer, but he knows that. I'm like, I was a nurse for 17 years and I had never heard of this condition because it's rare. So I'm like, okay, so he's got an expert that's going to talk about that, and is going to talk about how when they hit the ground this happened, or when they hit the tree, because he said, like, he's asked the medical people on cross, could it happen when they hit the tree? Could it happen when they fell to the ground? He was basically blaming the condition and blaming her injuries on the boyfriend, because the boyfriend tried to separate them, and when he did, they fell. And so he's saying that's what caused this condition that is going to maybe give her problems down the road with her breathing or whatever. And that's a possibility. If they're public defenders, I don't know if they're public defenders or not. But that's what I expected, at least that. But no. And then I'm trying to remember, what was the mom's attorneys, what was that defense? Does anybody remember? So dad's attorney was just, it didn't happen the way everybody says it happened, even though we had the video right there, and that it was actually the boyfriend's fault that she had that condition and had to stay in the hospital an extra day or whatever. And then I don't remember what the mom's attorney said. It was something equally as strange. I don't remember what it was. But then they didn't put anybody up to back up what they said in opening, which is the point of opening. You're going to see this, you're going to hear this, and then you put your witness up there. Well, yeah, but if they're public defenders, though, don't they get allotted money by the state for their witnesses, too? I mean, I know they're very expensive, but still, they're allotted some money, right? Because remember with the whole Sarah Boone thing, they had hearings because she was public defender before she was pro se, and then she had the miracle dude that just showed up out of nowhere. She had hearings that were all about how much money she could get for certain witnesses. So, I mean, yeah, it's probably not much, but I mean, at least they could have got somebody. But yeah, I don't understand not putting on a defense because it's not going to hurt. I mean, at least you've tried. Yeah. So, in the last stream, I was like, I don't know. And see, in the last stream, I guess some people might have got upset with me because I don't know the rules of evidence. I'm not a lawyer. And I was just like, why can't they get like some religious expert that knows the Quran that can say, that this is their religious norm or whatever, even though it's not going to work, just to try to fight, to say why they did it, even though it's not going to work, because I'm an optimist. Just at least try. If you're not going to try, why are you going to trial? And they're like, well, that's not proper, and you can't bring religion in, I'm like, I'm sorry. I didn't know. I'm just saying. I'm an optimist, just try. It can't hurt to try. It can never, my thing, I say it all the time, and I probably say it too much. I'm like, the worst thing they can do is say no. That's, that's my thing. What are they going to do? Tell me no. Is that going to kill me? No. I'll try anything. That's just, maybe it's because I'm a cancer survivor. I don't know. I didn't used to be this way. I'm an optimist. I'm like, is it going to kill me to ask? The worst thing they can do is tell me no. And that's just the way I live my life now. And maybe people don't see things that way, but I'm like, so what? Try it, That's just me. And I guess I offended somebody in the last stream because they were like, you can't do that. I'm like, I'm sorry. I'm just being optimistic. I'm like, why even go to trial if you're not going to try? Why? They're not even doing anything. And their questions, half of the questions were like a repeat of what the prosecution asked. And I'm like, what? What good does that do to just ask the same questions the prosecution asked? And then when they did ask questions, especially the dad's attorney, like the pediatrician, Joyce Gilbert, she was the sweetest little lady. She looked like a grandma. I was like, the kids probably love this woman. And he asked this woman because she got brain swelling from being choked. All the blood stays up there because you're being choked, you can't go back down. Your brain swells. So he asked this woman, can your brain swell from hitting your head on a hard object? And she says, yes. Could her brain have swelling from hitting her head on the tree. Yes. But she didn't have any bumps on her head, and she would have had a bump on her head but she didn't have a bump on her head. And even if she hadn't gotten a bump on her head, I touched her head and she didn't have pain anywhere. So she didn't bump her head. So she didn't hit the tree hard enough to cause brain swelling. So he is talking, like he's asking all the medical what else could cause this condition? What other way could this have happened? Like, he's trying and he's not getting anywhere with these questions. So I expected him to bring in his own medical witness when it was his turn to back up his position, and he never did. And I'm like, what are they doing? Like, it made no sense to me. Maybe I'm naive. I don't know law stuff. I mean, I know a little bit, but I don't know a lot of law stuff. Maybe I'm just naive and don't know what's going on, but I don't understand the purpose of going to trial if you don't have a defense. It's like a waste of taxpayers' money, a waste of the jurors' time. I don't understand. I just don't understand it. I don't know. Because religious law is not legal law. I was like, okay, I get it. It's not lawful law. like Brooks, it's not lawful law. Okay, I understand now. It's not lawful law. But I guess because religious law is not legal law, so you can't, because like I was like, I'm Christian. Our laws, like biblical law, doesn't trump government law. Right, Jill? Our Bible, we have to obey the laws of our government. I guess maybe that's different with the Quran. I don't know, because I'm not Muslim. But that's what I wanted to know. Like, I wanted someone that knew, like, Muslim law, so I could understand why they did this to their child. But I guess they can't do that because it's not legal law. I guess. I don't know. I want a motive that makes sense. I wanted to hear them defend themselves. I wanted, if nothing else, them to say, our daughter ran away and we wanted her to come back home and we were disciplining her. If nothing else, like, I wanted to hear a defense. And you guys, you all wanted to hear a defense too. Don't act like I'm the only one in the room that wanted to know what the defense was. You all wanted to hear it too. Don't give me a hard time. Yes, they should have taken a plea. They should have taken a plea and pled guilty, but I imagine, I bit my tongue. I imagine there's also like a pride thing going on too, where they don't want to admit they were wrong. I don't know. I mean, because the honor killing thing, that's a pride thing, right? Because she's dishonored their family. So I imagine it's. I know. That's what I'm saying. So all this crap that I'm throwing out here that I know nothing about is just me trying to figure out what the heck is going on. Because why are we here? I don't get it. See, Jill, this is why we're twins. We're both thinking the same things right now. I don't get it. Why are we here? I don't know. And so now we're just going to be like, we're still, Monday, we're going to be sitting here going, After closing arguments, we're going to be sitting here going, what the heck was that? I know we are. We're going to be like, okay, what? Man, I wish my eyes would quit watering. I have an eye appointment in September. And I'm going to try to ask her. Last time I asked her, she forgot, I guess, because she never answered me. I got to find out why my eyes water all the time. Because it drives me crazy. They just drip down my face constantly. Yeah, well. Yeah, there's that. And I imagine Verdict Watch is going to be really short, too. Yeah. I can't imagine a culture where it's okay to unalive your own children. I can't imagine. But earlier in the trial, we were talking about it. Why didn't they do that to their oldest child? Why didn't they marry off the oldest child? And we figured because maybe she was the good kid, that did everything they told her to do. And Fatima wanted to be more Americanized, and have a boyfriend and a normal. The one thing that I have not, because I did see the video, the unredacted video, but you can't hardly see her because everybody's on top of them. Does she wear a hijab like her sister and mom? Because I can never see her face and head because everybody's on top of her and her dad in that video. So, does she even wear one? I mean, I guess, like, is she one of those girls that wears one when she leaves her parents' house and then takes it off when she goes to school? Because I know there are some. She is wearing it? Okay. I didn't know. Well, in the hospital, but when I was a pediatric nurse, I took care of a Muslim teenager, and her mom would, she wasn't there all the time, but she would come and go. And it was like a step down unit. It wasn't the ICU, but it was a step down unit. So they were watched more closely. So it was a 3-bed unit. So we had like a nurse's station with 3 beds on this side. It was 6-bed unit. It was 3 beds on this side and 3 beds on the other side. So we were right there all the time. So I monitored 3 beds right there. So I didn't have like patients, down halls that I was, they were in private rooms or whatever that I was running back and forth. I was right there and I monitored. And they had boys in there and girls in there. So of course, I still know nothing about the Muslim, very, very little about the Muslim faith. And she wasn't wearing her hijab or anything when she was in the bed. And I was told that men were not allowed to see her without it on. So I kept her curtain pulled around her bed because diagonally across from her was a teenage boy. So I kept pulling her curtain, and her mom had the hijab, the whole black dress, everything, head to toe, like you could only see her eyes. And I kept pulling. Every time I go do something, I pull the curtain behind me, and then when I got done, I pull it back. And so her mom came over to me after, I think it was maybe the second day I was taking care of her, and she goes, why do you keep pulling her curtain all the time? Is there something wrong that she's not allowed to see the rest of the room? I was like, oh, no, ma'am, I was just doing that for your privacy. I can leave it open if you want me to. And she goes, okay. Like, the other nurse told me to keep it pulled because she wasn't in her hijab and everything, and nobody was supposed to see her if she wasn't in it. And then her mom was like, "Oh no, it's okay. You can leave it open." And I was like, "Okay." So I don't know, so I didn't know what to do. But I mean, her mom was really nice about it, but she thought like there was some order from the doctor or something to keep her isolated, and I'm like, no, I just was for your privacy. Like I didn't say anything about the religious aspects or anything, or that I was told, or I was just like, oh no, it was just for your privacy, because you got a teenage kid that's a female, and then you got another teenage male over here anyways. You want a little bit of privacy anyway. And so I was just like, oh no, it's just for your privacy. And she's like, oh, it's okay, don't worry about it. And I was like, you can leave it open. So that was interesting. But so that's about all I know. They're not allowed. Oh, and I've also had Muslim um parents with sick kids that I've walked in on them when they were doing the morning prayer thing. Like they have to do prayers at certain times of the day. I think that's Muslim. Is that Muslim? And I've accidentally walked in on them while they were doing, and then like, ooh, and then like walked out real quiet and been like, I'll come back later. That's embarrassing. But yeah, being a nurse is you learn. I mean, you don't learn everything about other cultures, but you see a lot of different cultures when you're a nurse, and so you have to learn to respect other cultures, and so it's quite interesting being a nurse. I miss it. I miss it a lot, but I couldn't do it now. I can't. I hurt too bad. I get grumpy when I hurt. Yeah. Yeah, that's my understanding too, but I was shocked because but they were American though. They weren't. Yeah, but it was like a step down ICU. Well, actually, they called it a step down. Like they hadn't been in an ICU. They needed more monitoring than like just being in a regular room. So the way it was set up, it was like one big large room that had a nurse's station in the middle. So that one nurse was on one end of the station, one nurse was on the other end of the station, and there were 3 beds on each side. And they would try to keep it like boys on one side, girls on the other, but sometimes they would have to mix them. So I ended up that night, think I think it was 2 girls and a boy. So the boy was like, the 2 girls were side by side, and the boy was like catty corner away. So they tried to keep girls on one side and boys on the other. A lot of times it was babies in there too, so it didn't really matter that they were mixed. But they didn't do that. Like they tried to keep it separate, so they didn't do it a lot. But that was like they needed a little more monitoring, so you were a nurse right there in the room with them all the time. And then they only kept them in there until they didn't need the extra monitoring, and then they put them in a regular room. So, but yeah, they were American, and I don't know if that had anything to do with it or not. Yeah, because they didn't sound Middle Eastern. They didn't have an accent. They were black. They weren't um like they didn't look like Middle Eastern. They looked like African American. So, but yeah, they were like nobody, no males, especially no males can see her without her head covering on. So I was like, okay. So keep her curtain pulled. So I kept her curtain pulled. So, but, yeah. So that was probably, maybe, my first experience with a Muslim person. I think it was, actually. But then after that, because being in the hospital, you're in all kinds. I know. I know. And of course, back in my, let's see, I was in my mid to late 20s when I worked at the hospital. And I had been an LPN for 9 years when I got my RN, and I went from the nursing home where I was very comfortable and very professionally sure of myself to being an RN at a hospital. So it was kind of like starting over and being brand new. So like I wasn't professionally sure of myself. And so now I am with different cultures, different languages. We had a lot of Spanish patients. And thank goodness we had Spanish nurses though that I could say, come here and translate for me. So it was a little nerve-wracking at first, but then I got pretty good at that too. But then I hurt my back and ended up going back to the nursing home because it was easier. But long story short, but yeah. So yeah. Well, so I guess if she wore her hijab, she wasn't totally rejecting them. I mean, because like I've seen stories where like the girls want to be American, so American that like they don't even dress like they'll dress like that when they leave the house, and then they'll have clothes stashed somewhere and like dress American, for school, and then change back for when they go home. But I thought the defense would be, well, she was running away from home and I was just trying to get her to come back home. But the other thing I don't understand is why didn't he try to get her in the car and then take her home and then do whatever he was going to do? No. I hurt my I hurt my back moving furniture at the hospital. And then I couldn't even get workers' comp because I have fibromyalgia and have a history of back pain. Stupid workers' comp. And then somebody in chat yesterday said that it wasn't even technically an honor killing because it's it wasn't even an honor killing because that's like a ceremonial thing that involves other people. The way he did it, it doesn't even count as an honor killing. I really, really wish they had put on a defense because I want to know what was going through that man's head. I really do. I don't even think it was an honor killing. I think he was just mad at her because she wasn't letting him get his way. And I also think the fact that this man that he wanted her to marry had money, I think that has a huge, huge thing to do with why this went down the way it did. I really do. But I guess we'll never know. I don't think it was planned. Um, she heard her mom talking to her aunt on the phone. Now, I don't know if the aunt's in Iraq or if she's over here. But she heard her mom telling her aunt on the phone. So she knew they were planning a trip to Iraq. She got up in the middle of the night and ran away. And she went like to stores and stuff that was open. And then as soon as school opened, she went to school and she told school that she was running away. And they got her resources. They got her a laptop. They got her set up in like, I guess like a homeless shelter for kids. Like And so they kept her at school and safe until school let out, and she was going to get on the city bus to go to the shelter. And that's when her dad showed up. So I don't know if I don't think it was planned. I think they were just looking for her, and he went there to look and found her, and then. But the thing that makes me mad, if I was Isaiah's dad, I would say you charge him with that assault, because he was trying to separate Fatima and her dad hauled off and punched him. And if I was Isaiah's dad, I would want that. I mean, I know with all the other charges, that's just a drop in the ocean, but I still would want that prosecuted along with everything else. You don't punch my kid. He's trying to keep you from killing his girlfriend. Unbelievable. I mean, we were talking about this the other day too, that in my day and age, kids would not jump on an adult. We would run to the school and get a teacher. But because that's the way we were taught. Kids my age, my generation. But still, adults don't just haul off and punch a kid. No. Oh my gosh. No. No, no, no. I mean, that's why the mom had the protection order and the trespass order for the school, because she had gone there and punched Isaiah already. So the mom punched him first, days before, and then the dad punched him that day. So okay, well, I am gonna go. I guess I don't think I'm gonna stream tomorrow, y'all. I've had a bad week between the surgery Monday and being at the hospital all day long, and Belle being sick this week and finding out that she's really sick, bad sick, maybe cancer sick. You're so cute. I'm gonna miss you. And I'm just tired. I'm gonna take an extra day off. Cause yeah, I didn't stream Monday, but I did not get any rest Monday. I was miserable. Um, so I think I'm gonna take tomorrow off. If I change my mind, hopefully you'll get a notification. I don't know what YouTube's doing nowadays. I guess maybe Monday morning. We might do Phil Spector Monday morning, and then if there's anything left of the charging conference, we can do that before closing arguments start on Monday morning. So you guys have a good weekend, and we will do this again on Monday. Yeah, yeah. Why didn't he take her home and do it? I'm glad he didn't, because if he had done that, then she might not be here right now. But oh well. Okay, guys. Be kind to people, love your family, and Jesus loves you, and so do I. Bye, guys. Have a great weekend, and I will see you guys on Monday. I love y'all.